everyone. I'm Curt Levey, president of the Committee for Justice. I want to welcome you all to the latest in our series of Zoom panels on everything from the Supreme Court and the Constitution to debates over antitrust law and the regulation of big tech. This panel is about the nomination and confirmation of Ketanji Brown Jackson, otherwise known as KBJ. Jackson's hearing begins, seems awfully fast, but begins a week from today. So this is a great time to look at her record, assess how the confirmation process is going so far, discuss what should and likely will happen at her hearing, compare it all to previous Supreme Court battles. We'll also look at the implications of this confirmation fight for the November election and the Biden presidency. And we'll do this all with the help of our panel of SCOTUS experts, Clark Neily, Dan McLaughlin, and John Malcolm. Should be an interesting discussion because we have one panelist, John, who has been critical of her record. One who supports her nomination, that's Clark, and one Dan who has cautioned Republicans to not attack her too much. After they speak, I'll ask them some questions. We'll include some audience questions that come through the Zoom Q&A function or that have been emailed to us. And I guess let me just introduce the panelists in the order that they'll speak. John Malcolm is at the Heritage Foundation, where he's the vice president of the Institute for Constitutional Government. He's also the director of the Meese Center for Legal and Judicial Studies. Before joining Heritage in 2012, he was general counsel at the U.S. Commission on International Religious Freedom. And before that, he was at the Justice Department, and then he was executive vice president at the Motion Picture Association of America, leading their worldwide anti-piracy operations. He's a graduate of Harvard Law School. Next, we'll hear from Clark Neily, who's senior VP for legal studies at Cato Institute. Before joining Cato 5 years ago, he was a senior attorney at the Institute for Justice and director of their Center for Judicial Engagement. He served as co-counsel in the landmark Supreme Court case that you've all heard of or should have heard of, District of Columbia v. Heller, in which the court held for the first time that the Second Amendment protects the individual right to own a gun. And he's the author of Terms of Engagement, How Our Court Should Enforce the Constitution's Promise of Limited Government. And he's a graduate of the University of Texas School of Law. Dan McLaughlin is a senior writer at National Review Online. He's also a fellow at the National Review Institute, and he was a real lawyer till not long ago, unlike many of us here in DC, practicing securities and commercial litigation in New York City. He was also a contributing editor to Red State and a columnist at The Federalist. Perhaps most interestingly, to me at least, he was a baseball blogger for several online publications. I believe he's a Met fan like myself. I'll let him tell me if I'm wrong on that. And he's a graduate of Harvard Law, where one of his classmates was KBJ. I also overlapped with her at Harvard, but neither Dan nor I remember her. Well, let me ask John to start it off then.
Well, thank you, Curt. I'm delighted to be here with this panel, and congratulations, Dan and Curt, on the Max Scherzer pickup for the Mets. So I thought I'd talk a little bit about Ketanji Brown Jackson's background and a few of the issues that I think are likely to come up during these hearings. So a little biographical information. She's 51 years old. She's a graduate not only of Harvard Law School, also Harvard College. She clerked for 3 federal judges, including Justice Stephen Breyer, the justice whom she would replace if confirmed. She spent time in private practice at several law firms and also spent 2 years as an appellate lawyer with the Federal Defender Program here in Washington, D.C. In private practice and as a federal defender, she worked on several matters that are likely to come up during her confirmation hearing, including some work she did in several cases on behalf of detainees at Guantanamo Bay, filing amicus briefs, two of them in private practice. One of them, in fact, she filed a brief on behalf of Cato, and then also representing a Gitmo detainee while a federal defender. She also did work while in private practice, joining an amicus brief filed on behalf of NARAL and several other pro-abortion groups, supporting the constitutionality of a Massachusetts law that established a buffer zone around abortion clinics. She worked as an assistant special counsel at the U.S. Sentencing Commission, and then was later confirmed herself as a sentencing commissioner. Another issue that's likely to come up is the fact that while she was on the Sentencing Commission, the commission gave retroactive effect to proposed guidelines amendments implementing the Fair Sentencing Act. This had effect of increasing the quantities of crack cocaine required to trigger a mandatory minimum. It decreased the disparity between the sentences for offenders for crack cocaine versus powder cocaine offenders. And it also eliminated a 5-year mandatory minimum penalty for simple possession of crack cocaine. She also, these decisions, of course, enabled several thousand prisoners who have been previously sentenced to petition for resentencing. She also advocated somewhat controversially for the repeal of mandatory minimum sentences while she was a commissioner there. She was appointed to the district court by President Obama in 2013 and was elevated to the DC Circuit just last June by a vote of 53 to 44, with Senators Susan Collins, Lisa Murkowski, and Lindsey Graham voting with all of the Democrats to elevate her to the DC Circuit. There were 3 Republican senators that didn't vote. She's written nearly 600 opinions, but only a couple of them while on the DC Circuit. So there's certainly plenty of fodder there for the hearing. In terms of her record, I think that there are 4 areas that are likely to draw a fair amount of attention. First, Republican senators are going to want to know why Ketanji Brown Jackson is the preferred nominee of several very hardcore leftist groups like Demand Justice. That's the group that pressured Stephen Breyer to retire, hiring a van with a billboard saying Breyer retire now, that went back and forth in front of the Supreme Court. They had protesters and hecklers show up at a speech that he was giving to disrupt the speech and hold up signs saying Breyer retire now. Demand Justice has also led the charge to pack the Supreme Court, and it's now funding a multi-million-dollar or $1 million campaign to get Judge Jackson confirmed to the court. The second issue I think that Republican senators will be asking her about is her judicial philosophy, her methods for interpreting the Constitution. Last June, she said during her confirmation hearing to the DC Circuit that she really didn't have a judicial philosophy per se, which I think is a kind of a strange answer for someone who clerked for a Supreme Court justice and had been a judge herself at that point for 8 years. She also said that as a lower court judge, she wouldn't question the interpretive methodology that was utilized by the Supreme Court. But of course, she's not going to be so constrained if she ends up being a justice on the high court herself. She then said that it would be inappropriate to offer an opinion about legal matters that might come before the court. Of course, many Supreme Court nominees have said that. But delineating one's judicial philosophy is not a legal issue that is going to come before the Supreme Court for resolution. That is a matter that each justice and each judge, for that matter, decides for him or herself. Many Supreme Court justices, past and present, have written books and given speeches about their preferred methods of interpretation. And I think that she should be pressed to give an answer to those questions too. Third, I expect the senators will obviously ask her about some of the opinions that she has written. In a series of opinions, she has ruled in favor of labor unions in cases involving attempts by the Trump administration to limit their ability to unionize or to engage in collective bargaining. She was involved in a couple of cases that involved President Trump more directly. She joined an opinion while on the DC Circuit rejecting former President Trump's efforts to block the release of documents that were being held by the National Archives that were requested by the January 6th committee. She also wrote, as a district court judge, a very lengthy opinion that to my mind, included some gratuitously harsh rhetoric that compelled former White House counsel Don McGahn to testify before the House Judiciary Committee about alleged interference with the 2016 election. And she rejected President Trump's invocation of executive privilege. And in a couple of immigration cases, she also ruled against the Trump administration. In one, she ruled against the Department of Homeland Security's attempt to revise the rules regarding asylum hearings. And in the second, she ruled against DHS's attempt to expand the category of non-citizens who would be subject to expedited removal. In that case, she was unanimously reversed by the DC Circuit in an majority opinion written by fellow Obama appointee Patricia Millett. The court there held that the DHS secretary's expedited removal determinations were subject to his sole and unreviewable discretion. Finally, I think the senators are going to ask Judge Jackson whether, if she is confirmed, she will be willing to commit to recusing herself from consideration of the case involving racial preferences in college admissions that will come before the court next term. One of the two consolidated cases involves Harvard University, and she's been a longtime member of the Harvard Board of Overseers, which provides advice and counsel to the university on strategic matters. And it's inconceivable to me that their admissions policy in this ongoing lawsuit going on for several years now would not be a matter that would be discussed by the Board of Overseers. It's worth noting that on at least two occasions while she was a district court judge, she recused herself from cases involving university practices because of her affiliations with those universities that were involved in litigation. And with that, I think I'll stop and turn it over to my friend Clark Neily.
Thanks, John. Clark?
Well, it's great to be here, Curt, and thanks to John and Dan for letting me be the ham or the turkey in this libertarian versus conservative sandwich, I guess. Pretty clear what my role is here today. I would say this: one of the beauty and the sorrow of being a libertarian in DC is that we always know we're going to be disappointed by the next Supreme Court nominee, and the only question is how disappointed. Because in order to secure a nomination from a conservative or a Democratic administration, you have to evince belief in a number of what we consider to be rather outlandish aspects of Supreme Court doctrine, including, for example, that the doctrine of enumerated federal powers is essentially meaningless. And the only question is whether 99% of the federal government is permissible or 100%. And this is not a particularly interesting debate to us libertarians because we see things quite differently. But we know that there's never, probably almost certainly in our lifetimes, going to be a Supreme Court nominee who will, for example, stand up for the principle of enumerated federal powers. Well, actually, I should say we've got one justice with a coherent theory of the 14th Amendment's privileges or immunities clause, but 1 out of 9 is no great shakes. And so the point is that we've grown used to being disappointed. And then the question becomes, as I said, just in what particular way are we going to be disappointed by the latest nominee? And it seems to me that the confirmation hearings have become quite uninteresting because it's almost like going to a movie where you already know who the major players are and what the plot is going to be, and even to some extent the outcome. If it's a Republican nominee, then you know for certain that the Dems will oppose the nominee. The only question is why. And then vice versa, the same thing. If it's a Democratic nominee as it is now, then the one thing you know is that the Republicans, conservatives will come out against that person. And really the only suspense is why. Why are they going to come out against the person? And it's become, I think, kind of uninteresting because, again, you know the broad brushstrokes. And it's just going to be a question of what particular things do they throw up against the wall. In my view, the question is not, would I have chosen this nominee, or would you have chosen this nominee, or would John or Dan have chosen the nominee? The question is really quite simple and binary, and that is the nominee qualified to be on the Supreme Court of the United States or not? And that seems to me a very easy call in this case. Ketanji Brown Jackson is manifestly qualified to be on the Supreme Court of the United States, in my view. I think it might be interesting in some other setting to have a discussion of who members of this panel might have preferred, but that's really not the issue in front of us. And so I don't expect the hearings to be particularly interesting. I think unless some new and quite, let's say, shocking information comes to light in the next week or so, it seems to me that basically everybody who's tapped into what's going on around town recognizes that the only question will be by what margin is Judge Jackson confirmed, not whether she will be. And I think that's exactly right. My hope is that there will not be a great deal of character assassination and undermining and belittling of this nominee. I don't think she deserves it. And I think that her track record, while somewhat unusual in the sense that she spent most of her time as a district court judge as opposed to a court of appeals judge, her track record is well within the margins in terms of a confirmable judge. I do think it's worth talking a bit about this question of, whether she's the most qualified judge available. I think that is a nonsensical construct. I don't think there's some hierarchy according to which, if you're just smart enough, you would be able to, check the boxes and assign scores to the various categories. And then you would say, well, this judge here represents the maximum combination of erudition and constitutional learning and judicial temperate and so forth and so on. And then so when I put it into my judicial calculation machine, this nominee is the most qualified one in the land. That's a preposterous construct. So the real question is, I think, you have to answer this question, I think, to some extent in terms of what's already on the court. From my view, and no one who's been listening to me beat this drum the last couple of years will be surprised to hear this. The most significant thing about the federal judiciary and the most significant thing about the Supreme Court is the extraordinary overrepresentation of former government lawyers, and specifically former prosecutors and former courtroom advocates for government. There's only one justice on the court currently who never represented the government in court, and that's Amy Coney Barrett. And she took the place of the only other justice of the current era who had not represented the government in court, Ruth Bader Ginsburg. So from my perspective, the views, the sentiments, the prerogatives of government are abundantly well represented on the current Supreme Court, as indeed they are on the judiciary. And so, as a libertarian and as a citizen who believes that a diversity of perspective and a diversity of professional experience are both quite desirable, I'm highly encouraged about the fact that Judge Jackson, if confirmed, would be only the second justice since Thurgood Marshall, or I should say the first justice since Thurgood Marshall, with criminal defense experience and the first public defender in the history of the court. Now, I don't fetishize that. I don't think that makes somebody uniquely qualified to be a Supreme Court justice. I simply say that I think it lends important perspective to an institution that spends a significant amount of its time adjudicating the rights of criminal defendants and the scope of government power when it invokes its awesome power to prosecute and incarcerate people. And I think that a Supreme Court that lacks people who have represented defendants in criminal proceeding is by definition lacking in appropriate perspective on one of the most important questions that comes before the court. So I'll wrap up by saying that I think that if I were president, for example, there would be a number of disqualifying characteristics that for me would be disqualifying. A nominee that had never spent significant time thinking about unenumerated rights. What rights, if any, does the Constitution protect that are not specifically listed in the text? If you've not spent significant time thinking about that, I consider you to be, if not unqualified for the court, then certainly you're not going to be my nominee. Same thing if you cannot articulate a coherent theory of enumerated federal powers and give me a more or less plausible estimate of the percentage of the current federal government that is not plausibly within the enumerated powers set forth in Article 1 of the Constitution, you will not be my nominee. And third and finally, and this is highly relevant to Judge Jackson, if you are unable to provide any meaningful insights into the process that has come to displace the constitutionally prescribed jury trial as our default mechanism for adjudicating criminal charges. And that is, of course, what we euphemistically refer to as plea bargaining. As the Supreme Court has said, plea bargaining is not some mere adjunct of our system. It is our system when it comes to criminal justice. If you've not thought about plea bargaining, and specifically the rampant use of coercion to induce people to waive their right to a trial and plead guilty, then you will not be my nominee to the Supreme Court. Notably, Judge Jackson is the first Supreme Court nominee that I'm aware of who has thought about this issue, or at least written about it in any significant way. She wrote her senior thesis at Harvard on coercive plea bargaining. I commend everybody's attention. That's included in the materials that she submitted to the Senate Judiciary Committee. It is a brilliant piece of work. And the fact that it was done by somebody in their early 20s as an undergraduate is extraordinary. And it evinces some very originalist and has many quotes from some of our friends like Alexander Hamilton and the other Federalist writers on this topic. I won't belabor it, but I think that if I had to pick one of a very small list of qualifications that I would absolutely insist upon if I were considering appointing someone to the Supreme Court, long and deep thought about coercive plea bargaining and the way that it has virtually destroyed constitutionally prescribed jury trials in this country would be very near the top of my list. And lo and behold, she's the first Supreme Court nominee that I'm aware of that checks that box. So I'm in favor of her. I don't know that I would pick her necessarily if I were president, but she's absolutely qualified, and I think she's going to be confirmed easily, as she should be.
All right. Well, it falls to me then to talk a little bit about. I guess I would follow what Clark said first of all by offering you all my own very quick list of sort of what my own qualifications would be in choosing a justice. I mean, I've written about this. I think number one, the job is fidelity to the Constitution as written and the laws of the United States as written, and recognition that the writing of those things down is very important. And that represents the democratic legitimacy of everything the court does. So, I mean, to my mind, the absolute overriding qualification for a Supreme Court justice is faithfulness to the text. And there are different ways of looking at how one does that. But it has to start with the fact that the text was written by people who were elected, and you're not. The second qualification, I think, and all of the experiences that we look to in justices, I think a lot of them are really secondary ways of finding out who has the reasoning ability, the writing ability to reach decisions, not only reach decisions that are thought through, and that are thought through not only for how they affect the case at bar, but many other cases, but also to explain the court's decisions. One of the hugely important things is to explain what the court has decided in a particular case and what it hasn't. There are lots of issues that come up before the court over and over again. A judge who is not good at explaining those things is going to create a lot of repeat litigation. And worse, there are many areas that the court drops into, writes an opinion about, and doesn't come back to it for 20 years. And if that opinion is not well written, it will create havoc in the lower courts. And my third criteria really is a certain level of wisdom and experience about the world. How the world works, and not merely the law books. I think to understand, to apply your intellect to the law, I think you do need to be a certain amount of a worldly person. Justice Scalia, who's maybe one of my, along with Thomas, my ideal of a modern justice. Scalia often brought a good deal of political philosophy to his opinions, but that was not as a substitute for the text, but as a way of understanding. What does the structure of the separation of powers mean? How do governments exercise power? Now, one thing I would not use as a criteria for, certainly not a frontline criteria as opposed to simply a way of checking to make sure you cast a broad enough net of candidates, is to select the nominee by race and gender. And I think that Joe Biden has come in very properly for criticism, and the criticism ought to be aimed at the president and not at his nominee, for the fact that the president said right off the bat that he was going to choose a black woman in a single strike, eliminating about 97% of the potential candidates right off the board. So with that in mind, I have sort of a list of do's and don'ts for Republicans who are Senate Republicans looking at this nominee, how they should approach the hearings. And of course, one of the first of those is don't obsess over race and gender. Democrats are going to want to make it all about that. I think it's clear that the voters already disagree with what Biden promised to do. And it can be helpful to remind people, perhaps, as repetition is often important, that Biden made those promises. But I think it would be a very bad idea to sort of go after the nominee to any significant extent for the fact that there was a race and gender criteria here. I think the voters get that. I think you're going to get as much political mileage out of it once, among voters who know that, without having to beat them over the head with it. And the Democrats will absolutely be, primed and ready to talk about that stuff. So I don't think it should be the Republicans' focus. Number two, be realistic. The Democrats have 50 votes. Kamala Harris can cast the 51st. Even the Mavericks in the Democratic Senate caucus, like Manchin and Sinema, have regularly voted for Biden's judicial nominees. So in all likelihood, Republicans cannot stop this nomination unless they unearth something that shocks and turns around the positions of Manchin or Sinema or some other Democrat. And so because of that, it may even be a safe vote for somebody like Susan Collins or Lisa Murkowski, both of whom voted for Jackson on the DC circuit, and possibly some others, to say, you know what, the president gets his choice. Because historically, if you look at, the year of a midterm election, the president does get his choice almost every time. And in those rare occasions when a nominee has been sunk, it's only happened once since the beginning of popular Senate elections that a president got his nominee sunk in a midterm election year. He promptly sent up another choice and got it through. So the chances of Republicans running out the clock and getting to keep this seat open at length are slim to none. And Slim has one foot out the door. So in that sense, Republicans should be looking to do a couple of things here. One, of course, is to try to pin down Jackson on a few things as to what she will do on the court. And first and foremost of that, I think in terms of concrete results, is to ask her about recusal in the racial preference case. And I think they need to focus not only on recusing from the Harvard case, but recusing from the case that is coming up with it, the North Carolina case, because those two cases are consolidated. Putting on my sort of legal ethics hat, you would treat these to a large extent at the Supreme Court level, at least, as kind of a joint defense. The Harvard and North Carolina lawyers are undoubtedly coordinating a common approach to argument. The cases have been set to be argued together. There's no practical way to separate them. And I think the senators ought to, and they stand a good chance, I think, of getting Jackson to promise that she'll recuse herself from those cases. It would not surprise me. She has said things, as noted in other cases and whatnot, that would suggest that she sees that she has to recuse herself. I would say also, don't go full Kavanaugh. Don't try to burn down Jackson with, personal attacks that are overreaching. I think what we saw in 2018, it was a very bad year for Republicans in the midterms. Democrats did very well in the House. They did very well in most gubernatorial races. They underachieved a bit in the Senate. Republicans knocked off 4 incumbent Democratic senators. Very, very unusual thing to happen when the other side is enjoying a wave election. And there's no question that the Kavanaugh hearings, which were enormously polarizing, had a big effect there. So, there are certainly people who are out for revenge, in the sort of conservative media world, who are saying, look, this is their rules. We got to play by their rules. They made life miserable for Kavanaugh, smeared his good name forever. We need to do the same thing, sort of the Chicago way thing, right, from the Untouchables. You put one of yours in the hospital, you put one of theirs in the morgue. And I understand that kind of thinking, and there are times when it is an appropriate way to approach partisan politics to a certain extent. But I think this is the wrong case for that. I think the personal attacks really blew up in the Democrats' faces. And when the other side is making a mistake, the thing you should not do is imitate them. So I would advise against personal attacks. I think probably it will be a mistake for Republicans to go too hard, although they're undoubtedly going to do, some people who are preparing to do this after Jackson's work as a lawyer, particularly representing criminal defense. I understand it's a different thing to talk about, say, her work for NARAL when you're doing an amicus brief on an issue like abortion. A big law firm is not going to put somebody on that case who isn't devoted to it, because they've got plenty of people lining up for the case, and they would easily, if somebody comes to you and says, "Oh, I've got this appellate case on an abortion issue," and you have strong feelings against what the firm's client wants to do, you're not going to end up on that case, right? It's just practical matter. So there's no question that is a representation that she should be asked about. But particularly since it is not only about abortion, but about free speech against abortion protesters. But I think beating up on her for representing criminal defendants, even in Guantanamo, is probably not going to work out that well, particularly at a time when there's a significant sort of illiberal move on the left to try to get the bar admissions revoked for people who represented Donald Trump and that sort of thing. So I think that would not be the most principled stance. I would absolutely, however, think that Republicans ought to be pressing hard to get more out of her on her judicial philosophy and how that interacts with her experience. She told Ted Cruz last year, a year ago, that I have not had any cases that have required me to develop a view on constitutional interpretation of text in the way that the Supreme Court has to do, or has to have thought about the tools of interpretation. So she wasn't simply saying, well, I don't really have a judicial philosophy. She was basically saying she didn't have the experience to do that. She hadn't given it adequate thought. And in the year since then, she has not had any cases that would change that. She's only published 2 opinions, she's been on a few other unpublished dispositions, but nothing much that requires her to give significant thought to how the Constitution should be interpreted. So I think Republicans will be very much within their rights, particularly with questions lingering over Biden's selection criteria, to press Jackson hard to find out, has she really not thought this stuff through? It's fine to be an experienced lawyer, but if the interpretation of the Constitution is so central to what the court does and its unique role in our system, I think Republicans should be doing that. And frankly, if the ultimate goal here is for Republicans, on the one hand, to try to get some commitments out of Jackson, but also to make some political hay, I think ultimately the political hay that is to be made is to highlight that the two parties have very distinct views of how to interpret the Constitution. And certainly the Republican view is one that appeals to Republican voters, and often to swing voters who do consider the Republican position on this. And if the answer here is that somebody who clerked for Justice Breyer, she's willing to say, look, I approached the Constitution the way Breyer did, that's one thing, and that will help Republicans make their case. If she persists in saying, I haven't really thought about this stuff, that's really not going to go over very well politically for Democrats, no matter how personally appealing Jackson is. And I think she comes across as somebody who's very much not, a hair on fire political radical. She comes across a very normal person. But a very normal person who has not thought through how to interpret the Constitution is maybe not everybody's idea of an ideal justice.
Let me throw a few questions at you folks, but actually first let me ask, do any of you want to respond to what your fellow panelists said before I ask my questions?
Yeah, I got a couple of things. So one, I agree with Dan. I don't think the Republicans should make a big deal about the race or gender of Judge Jackson or President Biden's pledge, which he made when he was running and desperate to win the South Carolina primary. But that having been said, I expect that Democrats will, they already have, try to blast Republicans as being racist for talking about the pledge or, questioning Judge Jackson's qualifications. I've written a blog about this saying that I really consider this remarkably hypocritical in light of how Democratic senators treated, minorities and women who were nominated by Republican presidents. And I would point out that after Clarence Thomas was confirmed to the Supreme Court, that President Biden made some comments that made it quite clear that he believed that Clarence Thomas was not the most qualified nominee, and that had he not been Black, he would not have been elevated to the Supreme Court. The other thing I would say that I think should hearten Clark is that President Biden has made very, very clear on several occasions that he would only nominate somebody who has a robust view of unenumerated rights in the Constitution. He hasn't really talked about the Privileges and Immunities Clause, but he's waxed rhapsodic about the Ninth Amendment. And I would be very surprised if that didn't come up in his conversations either last year or this year with Judge Jackson. But I don't expect her to talk very much about it during the confirmation hearings. And she should be read some of those statements from President Biden, both as president and when he was a senator, talking about how important unenumerated rights are to him, and how his nominee will absolutely have to have a robust view of those rights.
Yeah, I would add to that Biden talked about that in his speech introducing her. So it is very much top of mind for him, and obviously to a certain extent that is code to Democratic voters for abortion, but not only abortion.
Yeah, no, I appreciate that from both of you. And, it will not surprise anybody to know that I, too, am a major proponent of unenumerated rights. I suspect perhaps not all the same ones that President Biden has in mind, and a great many that he does not. But long live Lochner. One point of agreement I would like to emphasize with, I think, all three of us, but certainly with what Dan said, was that I do think that somebody who is nominated to the Supreme Court of the United States should have a philosophy of the Constitution. They should be able to articulate at least some sort of basic framework for interpreting the Constitution. There are parts of the Constitution that are quite precise, like the requirement that you be 35 years old to be president. I think that is sufficiently precise that we won't be confused by that provision, even if we colonize other planets one day with different, whose years are a different length. The other end of the spectrum, you've got some rather open-ended and value-laden language, like I mentioned before, privileges or immunities in the 14th Amendment, or even simply the Fourth Amendment's prohibition against unreasonable searches, not a term that fills in its own blanks. The last point I would make is simply that this idea that, I don't have a judicial philosophy is not something that is unique to people on the left. Judge J. Harvey Wilkinson, a highly respected judge of the Fourth Circuit Court of Appeals and a perennial Supreme Court shortlister, has a whole book called Cosmic Constitutional Theory, in which he advances the position or the assertion that he himself does not really have a philosophy of the Constitution, and he just interprets it, the words in the way that makes sense. And so I don't agree with that. I wrote a pretty substantial piece in which I argued that, in fact, he does have a view of the Constitution. It's just that his view is that judges should almost always defer to the other branch's understanding of it. But so I do agree that a nominee to the Supreme Court ought to have a coherent theory of the Constitution. I simply would point out that the protesting that, in fact, you neither have one nor need one is not something that's unique to judges on the left. We've heard it from judges on the right as well. They're always mistaken, but it's a thing that we've heard.
Clark, you said it was very important for a nominee to have a theory on unenumerated rights and constitutional limits on federal power. If you had to guess at what Jackson's philosophy is, whether she wants to discuss it or not, would you guess that she sees it your way on those theories?
Well, I think in some ways probably yes, in some ways no. The easy one is I would guess would be enumerated federal powers. As I suggested earlier, we libertarians are used to being disappointed by absolutely everybody in the judiciary on this, or nearly everybody, and certainly everybody on the Supreme Court. So I would guess that she shares the traditional understanding of enumerated federal powers, which is that that's meaningless. It doesn't provide any meaningful limits on judicial power anymore. She's in good company there, obviously, with everybody on the Supreme Court, but or at least everybody who's weighed in so far. Maybe not every single person. On enumerated powers, I wouldn't care to speculate. I think it's pretty obvious that, or at least I think it's one would be safe in surmising that she will line up with progressives on many of the unenumerated rights that they care most strongly about, including particularly abortion and sometimes what are sometimes dubbed rights of privacy and intimate association. I wouldn't be as confident about her support for economic liberty and the right to earn a living. But again, she'll be in good company because there's nobody else on the court that appears to be supportive of those rights either. So perhaps this is just a case where, at least for some people, and according to some perspectives, half a loaf might be better than none at all. But I will be interested to see what she says if she's asked about unenumerated rights, what their textual source of support in the Constitution is, and what the scope of her understanding of unenumerated rights might be. I hope that does come up, and I'll listen very carefully when she answers those questions, as I hope she does.
I think you've already said she's, her view of what unenumerated rights exist probably is different from your view. Do you think that despite your support for her, you might in the end be disappointed with her because she does have such a different view of what rights are included?
Well, I hate to sound like a broken record, but I expect to be disappointed by absolutely every Supreme Court nominee.
Fair enough.
The only question is the scope.
All right. Fair enough, Clark. Let's see. John and Dan, do you have any thoughts on what her judicial philosophy will be? Again, even if she's not wanting to discuss it at this point.
Well,
I mean,
go ahead.
I'll let John go first.
Well, look, one can guess that there's a reason why demand justice is so supportive of her. The consequences are well, it's just less consequential than if you were replacing, say, Justice Thomas. This is, akin to Justice Gorsuch replacing Justice Scalia, and is very much the opposite of Justice Barrett replacing Justice Ginsburg. But one suspects that the people who are supporting her know her well. She has not exactly been a stranger at American Constitution Society events. Not that there's anything wrong with speaking at American Constitution Society events, but I'll bet you she's spoken a lot more of those than she has at Federalist Society events. And so, I suspect they know something that we don't know. It is certainly true that on the district court, she has not dealt with a lot of constitutional cases. She's dealt with a lot of administrative law cases, but we will wait and see. I mean, Justice Breyer, on some matters involving businesses, criminal issues, he occasionally would rule with the conservatives. I doubt that'll happen with the Justice Jackson, but we will see.
So
yeah, I mean, I think I think there are. Look, I mean, the Democrats have not. The Democrats have only appointed 5 justices the past 54 years, counting this one. And even if you go back, about a decade before that, not since Byron White in 1962 have they had what we might think of as like a suitor, somebody who they put on the court and then turned out to be much more conservative. And I would argue that White even was not that out of step with the president who appointed him. So it's been a long time since the Democrats have really, put somebody up there who didn't do exactly what they wanted. So, if you were looking at this as a conservative or a libertarian, I think there's not a ton of, you have to check your optimism. I mean, I think it's interesting that she has said at various times, and including her answer to Cruz last year, some things that sounded sort of originalistic about, the Constitution having a fixed meaning, and about, at least as a lower court judge, following, the interpretive methodology of looking to the original sources. I think it's perhaps more noteworthy to consider where some of her sympathies lie. Clearly, I would expect her to be pro-criminal defendant in a lot of ways. Of course, if you're a conservative, a libertarian, an originalist, there are a number of specific ways in which you would want a justice to be sympathetic to criminal defendants and to be skeptical. I don't know that I share Clark's view that there's a whole lot that the Supreme Court can or should be doing about plea bargaining. I think that's much more a question for an attorney general nominee. But certainly there are all sorts of ways in which federal law enforcement ought to be getting a certain kind of skepticism from the court. I think in civil cases, actually, private civil lawsuits, there's actually some reasons for perhaps optimism if you're a business friendly conservative, for example, that Jackson's record in those cases in the DC District Court has not been reflexively pro-plaintiff or pro-class action or anything. Although, if you know the docket of the DC District, they have a fairly small private civil docket compared to most other districts in the country. It's very heavy on criminal and administrative law. So, I think there are some things there. I think the reason to be concerned from a conservative perspective is that some of her sort of resistance era cases about the Trump administration, I think you can see some real signs of her bending the law to get where she wanted to go. I think the Make the Road case, which is a case involving, expedited removals of immigrants, I think she really just absolutely mangled that statute, which was, the DC Circuit said that there could hardly be a more definitive expression of congressional intent to leave the decision about the scope of expedited removal within statutory bounds to the Secretary's independent judgment. And yet she insisted, whether in sympathy for the immigrants or simply out of a refusal to let go of judicial review, on imposing judicial review, and the DC Circuit rejected that. So I think the signs of her perhaps bending and maybe doing a little bit of grandstanding during the Trump years are the things that should worry conservatives looking at what kind of justice this might be.
Yeah, by the way, I tend to agree with you, Dan, that although her overall record may not show that she's a judicial activist, at least when it came to Trumpian things, she did seem to be. Let me ask you guys, I know Clark thinks that it's positive that she was a public defender. And I have to say, I do think to some extent it is. How do you feel about it, John and Dan? Is it good news that we will have some diversity on the court as in terms of public defender background?
I think that's a valuable, experience. I'll bet you that some of the justices certainly did pro bono work, if not white collar work, when they were in law firms. I was prosecutor for a whole bunch of years and then a political appointee in the Justice Department. But when I was in private practice, I represented people who were under investigation and even was a defense attorney during a criminal trial. So I think that being a defender, by the way, she was an appellate lawyer in the defender's office, so she wasn't in court with those people, but it's legitimate work. It certainly gives you a perspective. I'd be surprised if it was unique. I'll bet you that there are some of the justices that have had some experience, probably at least in defending white collar cases, or they've certainly filed briefs against the government. I'll bet you some of them were in criminal cases too. But it is a steady part of the docket of the Supreme Court, and having sat across the table from people who have been accused or convicted of a crime, you certainly have a different perspective.
Yeah, I don't see it as I see it as a plus more than a minus, but I would caution, as John said, that she really only worked on appeals, so it's very different. As an appellate lawyer, you're not dealing with the uncertainty of somebody who's getting dragged before a grand jury and maybe has an investigation ongoing for years and never gets charged. You're not dealing with somebody who's had an arraignment, and so you're really dealing with somebody who's already been through the trial process and everything. So it is a little more limited, and she did that for 2 years. The other thing I would add as far as experience is as I noted, the DC, it's good, I think, to have some people on the court who have been district judges, because they are much more in the real world. But I think it might have been nice in adding a district judge, of which I think Sotomayor is the only one with district judge experience on the current court. It might have been nice to pick somebody who had a district court experience outside of DC, with more of a civil docket and less of sort of the kind of this town atmosphere of a lot of what happens in court in DC.
Now, let me add one other thing to that. I picked up on what Dan just said, which is she was a district court judge for 8 years. She had a total of 12 trials, and 3 of those were bench trials. That is a very low number for a district court judge. It's neither here nor there. There is plea bargaining and cases settle, and she has a large administrative docket. But when you're touting the benefits of having somebody who sat on the district court, and I don't underestimate those, it is a little atypical, because I bet you if they'd gone outside of DC, or possibly even with other judges within DC, they would have gotten somebody who had more experience actually sitting in a courtroom with a jury.
Well, why do you think at the end of the day that Biden did choose Jackson? People said that Kruger was more of a sort of intellectual superstar, a better writer. As a matter of fact, there was a objective analysis that suggested she's a better writer than Jackson, and certainly Child would have been seen more as a bipartisan pick. Now, I think Clark has already sort of answered that question by saying there is no perfect candidate, and within a reasonable pool, you can really pick whoever you want. So I guess I'll ask that question to John and Dan.
Well, I think obviously sort of the conspiratorial question that always gets asked is exactly the same one that was asked with Kavanaugh when he replaced Kennedy, which is, was there sort of at least an implicit promise to Breyer that he gets one of his old clerks to replace him, and that encourages him to retire? I suspect that there was not a conversation with the justice in either of those cases, but there's a grapevine in DC, and I think you can certainly put up signals. As Jackson was long considered to be top of the list well before there was a vacancy. So, I think that certainly helped her. And again, I think just, it's who you know. Childs had a powerful backer in James Clyburn, and that, that might have been enough, but it wasn't. So I do think that clearly there's, people have their backers. I think if I was in Biden's position, I might well have chosen Kruger, though.
Well, I won't comment on that last point, but Dan, I might well agree with Dan on that last point, but I'm certainly not president. Look, I think you have to look at the people whom the president was trying to please. And Michelle Childs was known as a tough sentencer in criminal cases. That goes against the zeitgeist of the left these days. And horror, she had worked for a major law firm and represented management in a number of labor cases, which I think caused a shortness of breath among many of the president's ardent supporters. And with respect to Justice Kruger, you heard whispers. She comes from a privileged background, not that Ketanji Brown Jackson grew up in poverty, like I say, Janice Rogers Brown, whom the president had opposed many years ago. But she was grew up in privilege, and she also had a reputation, albeit on a very liberal court, of being a moderate. And the people who accused her of being a moderate did not mean it as a compliment, and they certainly would have preferred having a Goodwin Liu, who was, her fellow justice on the California Supreme Court, than Leandra Kruger. So, you have to look at who the president was trying to please. And I think that Ketanji Brown Jackson ticked all those boxes.
Fair enough. And Clark, I don't want to leave you out, so I'm going to ask a question that we got from the audience, which is they're wondering, is this the first time that Cato, or not really Cato, because it's you and your colleagues who are supporting, or not Cato officially, but have you supported any of the other Democratic nominees? They're wondering, or is this a sort of new break for Cato?
Yeah, no, so it's important to emphasize Cato does not support judicial nominees. I personally have expressed support for this one primarily because of her professional background. I think it is incredibly important to begin to address the wild imbalance on both the federal judiciary as a whole and the Supreme Court in favor of former prosecutors and courtroom advocates for government. I think that's among the most troubling things about the federal judiciary right now. And so for me, that alone would be a sufficient basis on which to support it. It doesn't matter whether it's Democratic or Republican. Anybody who would begin to address this imbalance, provided they were otherwise qualified, which I think clearly she is, would make this person and this characteristic very appealing. So that's as far as I can go with that. I think she's well within the bounds of confirmability. I really hope, by the way, that everybody takes advantage of the opportunity here to try to begin to get confirmation hearings for Supreme Court nominees back on track. As I said at the beginning, I really hope that there's an absence of cheap shots and character assassination, that we see questions that are fair, reasonable, and germane, and that the candidate receive an up or down vote on the basis of her qualifications and not extraneous personal characteristics that really aren't relevant to the question before the Senate Judiciary Committee. I think there's a pretty good chance that that will happen. And my hat and my heart go out to anybody who keeps their professional their obligations to be a professional first and foremost, and forgoes the opportunity to just score cheap points.
And as a viewer of and writer on the hearings, I would say that one of my other great hopes is that we will see questions in the hearing that are actually questions.
Yes, rather than grandstanding. Well, I guess the good news is, and this goes to what Clark said, everyone was predicting that the judicial confirmation process could only go further downhill. And so far, this has been a relatively polite one. So maybe that's good news that there are limits on how low in the sewer that we can go. Somebody also asks, how is this going to affect court packing? I guess the obvious answer is to just say, well, it doesn't change the ideology of the court, so the left will still want court packing just as much. On the other hand, they do feel good about getting somebody who's clearly one of them and is young. So what do you think? Will this change at all the fervor for court packing on the left? And I ask this to all of you.
In the short run, yes. In the long run, no. So things have quieted down a little bit because the left has another preoccupation, which is getting Judge Jackson to become Justice Jackson. But once the Supreme Court issues some opinions, if they are not to their liking, as some of them are likely not to be, I think the fervor to pack the court will continue to grow. And as long as the legislative filibuster survives, that is not likely to happen, or at least is in lead. No, actually, you just change the Senate rule. So long as Senators Manchin and Sinema don't change their mind, then that is unlikely to happen. But we'll see.
Yeah, and the one actually somewhat significant way this does affect the court packing debate. Court packing is not likely to happen anytime soon. Unless the Democrats get a very large Senate majority. But the threat of court packing as a threat to the legitimacy of the court as a way of influencing the court is certainly something that is a big problem. And I think that Biden has to tamp down talk of that while he is trying to get his own nominee to the court through. And that's important because we are right now on the eve of sometime by the end of this term, likely Supreme Court decision on whether or not Roe v. Wade will survive. And certainly there are those on the left who would very much like to threaten the maximum possible consequences to the court as a way of trying to forestall the possibility of Roe being overturned. So I think it's a little harder to do that when you're simultaneously trying to get one of your own people on there.
Another member of the audience asks, can you ask John, but I think all of you could address this. On the affirmative action case, he says, can't the court simply uncouple the Harvard and UNC cases, which would allow her to take a part in UNC? Isn't that what the court did over faithless electors to allow Sotomayor to participate?
I don't remember what the court did with the faithless electors. That would be interesting if they did that. I mean, the cases have certainly been consolidated. As Dan, I think, pointed out, it was inconceivable to me that Harvard's general counsel did not speak with North Carolina's general counsel at some point, and that those communications were not conveyed to the Board of Overseers where Judge Jackson sits. So I can't imagine that she would try to split things in that sort of way. It seems to me too cute by half. But, justices control an awful lot when it comes to their own decisions to recuse. So we'll see.
Yeah, I mean, I think it's certainly the question of what the court could do to accommodate Jackson is one that the court won't face until she's on the court. And so Republicans stand a decent chance of using the political leverage of the hearings to get a commitment from her in advance of that. I think it would look very political if the court took these cases, consolidated them on a single question, and then suddenly tried to sort of backtrack after presumably the two universities had been coordinating and how to handle the case. I think that would look kind of fishy.
Do you think that Harvard and UNC and perhaps the community devoted to defending affirmative action feels that they've been somewhat thrown under the bus in the sense that Biden picked the person perhaps who he thought would help them the most politically, but that may result in one less vote for the left's position on affirmative action, which, again, I wouldn't blame them if they felt a little bit deprived. Any thoughts?
They might, but it would be a terribly ironic outcome given Biden's selection criteria for this job.
Good point. Any thoughts, Clark?
I don't really have any thoughts about the Harvard affirmative action case. I will say, going back to court packing, I was a little bit nervous at first because anytime I hold a position that could be fairly characterized as optimistic, it makes me, as I said, anxious because it strikes me as probably wrong. But Dan said something that I strongly agree with, which is the prospects for court packing seem pretty low. I don't know if it's a disagreement or not, but I would say this: if I were a conservative, which I'm not, but if I were, I would want progressives to never stop talking about court packing. I think that it is not a politically popular position. I think it is self-marginalizing. It seems that even during the New Deal, President Roosevelt's proposal to pack the court was not well received by ordinary Americans at all. I don't think that ordinary Americans are enthusiastic about expanding the size of the court now. And so I'm not worried about it happening. And I actually think that to the extent progressives continue talking about it as if it were a real thing, it's probably on balance going to undermine their position more than it is advance it.
Hard to say. You may be right, but I think that the public thinks less deeply and cares a lot less about separation of powers as a bulwark of liberty these days, and therefore the threat seems more real to me now, not in the immediate future. But you could be right in terms of the overall public perception.
Well, fair enough, and certainly it was not necessary to expand the Supreme Court in order for it to convince it to throw in the towel on meaningfully enforcing property rights, economic liberty, and enumerated federal powers.
Although the threat helped.
Yeah, and the failure of the court packing plan did not prevent Franklin Roosevelt from ending up having 8 Supreme Court justices whom he nominated, and Harry Truman getting the 9th, and it sat that way for a decade.
We only have a few minutes left, so let me wrap up with a question by asking all of you how you think this confirmation process and including the hearings and the ultimate vote when it comes to if they'll get any Republican votes, how will that all affect the November election and Biden's presidency?
Well, look, appointing a Supreme Court justice is a big deal. It's a large part of your legacy. He certainly honored the pledge that he made, and the odds are pretty high that she will end up getting confirmed. Of course, I don't know quite why there was a rush to do this, since the Supreme Court is not going to finish their business until the end of June, and Justice Breyer is still sitting there on the court, but the Democrats have their reasons for wanting to do that. It's a long time between now and November. We still have a war going on in Ukraine, and inflation is rampaging, and how much this will be on the voters' minds, I don't know, but this is certainly one pledge the president made that he honored.
Yeah, I think in the immediate term, I think she is likely to get confirmed. I think probably there will be 50 Democratic votes. I think probably there will be 2 to 4 Republican votes. I think probably Collins and Murkowski. I think there may be 1 or 2 others who I don't think Graham, who was the 3rd vote for her on the DC circuit, feels at all bound to be consistent with what he did before. But there's 1 or 2 others who may be sympathetic to her and feel that, well, if it's not close, I should burnish my bipartisan and credentials and historic nominee and all that. Politically, I think this is not going to make a ton of difference in the fall. I think, as John said, there's too much else going on. I think Republicans probably are not going to put up the kind of knockdown, drag out fight that keeps this top of mind in the fall. And frankly, if the court does something like overturn Roe v. Wade, nobody's going to be talking about Ketanji Brown Jackson when they talk about the Supreme Court on the campaign trail in the fall. So,
Thanks, Dan. Clark, any thoughts before we wrap this up?
No, I think it would be preposterous to predict what's going to be top of mind in November. I hope that the world's a more peaceful place than it is now by then. I'm not confident that it will be, but I think it's likely that there are going to be much bigger concerns facing us as a nation than the President Biden's delivering on his stated commitment to appoint a particular person to the Supreme Court. I think that'll be in the rear view long since.
Well, perhaps the good news for Jackson as she goes into her hearings is that perhaps the two biggest issues, inflation and the war in Ukraine, she will very unlikely be asked about. So she can be happy about that. With that, we'll wrap it up. I want to thank our esteemed panelists for what was a very interesting and entertaining panel. Of course, we could not have done it without such great panelists. So again, thanks to them, and we'll be back with another in our series of webinars real soon. Have a good afternoon, everybody.
thanks.
Thanks, Curt.
Bye.